Senate Committee on Science and Technology. Got one bill before us today, Senate Bill 473 by Chairman Albers. There is a sign-up list here. If anyone wants to sign up to speak, we would encourage you to go ahead and do that. Staff will circulate this if we need to. But Senator Albers, appreciate your time today. Appreciate you bringing this hefty bill, hefty subject, something that's been talked about for some time, and now there's some impetus to take actions. I appreciate your interest in it. I'm going to recognize you to speak. Is that mic working there?
Let's give it a try. Yeah, looks like
Chair
it. Thank you.
recognizes Chairman Albers. Senate Bill 473. Take it away.
Mr. Chairman and members of the committee, thank you so much for giving me the opportunity to present Senate Bill 473. As you just mentioned, Mr. Chairman, this has been something that's been very visible throughout our nation, beginning for probably the last 7 or 8 years now, as data privacy has become a bigger and bigger concern, specifically for end users. There are a spattering of bills throughout our country today, and candidly, we were, or I was waiting in hopes that this would be solved by a single federal solution. However, we're not confident that will ever happen. So many other states as well have taken action in order to make sure that we can protect people's privacy. But at the same point, this is a balance, right? We've got to protect employers, the businesses out there who have a right to go out and continue to build and grow their businesses, while at the same time we want to protect people's right to their own privacy. If we think back even just 10 years ago, not too many people were as concerned about people having access what's called PII, which is personal identifiable information. That has changed a lot, and I can imagine that everyone on this committee right now goes to a website to go look for something, and then you are streamed with ads and information about you. And if you want that, that's a good thing. But if you don't want that, there's a concern to make sure that people aren't holding on to that personally identifiable information and using it without your express written consent. So this little cleanup bill that's in front of you, it's actually pretty hefty. It's got multiple sections. And what I can do is I'm going to kind of just bounce through each section, Mr. Chairman, if that makes sense, at a high level. And then I know you've got some thoughts and input as well. And we'll go from there. So this is, again, the Georgia Consumer Privacy Protection Act. It is modeled after the state of Tennessee's. In the off session, I spent time, and I want to thank members from the Metro Atlanta Chamber of Commerce and the Georgia Chamber of Commerce and their numerous affiliates and folks that are chamber members, as well as members from the information security world and other areas, for helping to provide us feedback. We looked at all the different models that were out there and ultimately decided really just about 2 weeks ago that we were going to go with the Tennessee model, because we felt that it had probably some of the best combined language. And again, what this does is it allows consumers to exercise their rights regarding their personal data and establishes responsibilities for processors and controllers, and we'll define what they are. So section number 1 in most bills are always the same, and those are simply the definitions. And it defines, obviously, a consumer, and a consumer is a person, it's individual personal, and a controller is the person, along with others, who actually determines the purpose and meaning for processing personal information. And then the processor is the person that actually processes personal information on behalf of the controller. So if you think about it, we're really trying to protect the consumer and then making sure that the controller and the processors who have that data will be working with them in order to opt out of that information, to see what information they have, and we'll take that through the bill. But just to understand kind of who the key players are to begin. It also states that a consumer may invoke rights throughout this by submitting a request to the controller that can allow them to get access to the data, but also from a legal guardian. Obviously, if someone is under the age of 18 years old, they themselves would be working typically with a parent or a custodial guardian. The controller also will comply with certain things. They'll confirm whether they're processing somebody's personal information. Again, you'll hear that personal identifiable information or personal information throughout this bill. They can correct inaccuracies. They may have something that's just simply wrong about you in their systems. They also will be able to delete information that they obtained about you that they don't want anymore, or you don't want anymore, I should say. I'm sorry. They obtain a copy of personal information and give you the opportunity, and I think this is a big key, to opt out. Now, you may have noticed recently, if you have an iPhone especially, in a recent update not too long ago, all of a sudden apps would pop up and say, would you allow us to continue to track you because it'll help us to keep things free and et cetera, right? Well, Apple put privacy laws into place based on what other states were doing, right? Everywhere from Virginia to Colorado to California and everywhere in between who's adopted it as Tennessee. And they did that because they couldn't try and micro-target every state. So the reason why that's coming up now is because they are following the laws that other states have too. Now, not everybody is doing that, and they're not as big as an Apple is, but that's why you see these things, just to help you kind of connect the dots of what this is all about. And then the state's going to comply with a certain amount of things, such as an example is a controller has to respond without delay within 45 days of request from a consumer, right? So if I contact a controller and say, hey, I want to know what kind of information you have about me and what you've done with it, they have to respond to you. They can't ignore you, right? And similarly, if you then want to say, hey, I want out of your systems, right, then they will follow through on that. The information will be provided at no cost, so it's not as if you have to pay a fee to see where your own information is. And there's other things that go along with that. I won't get into every single line. It also states a controller will limit the collection of personal information to what's reasonably necessary. So think about how often you go to check out somewhere when you're buying something. And they don't just ask for your name and address and your credit card information. They may ask you 20 more things. Now, you may want to provide that because this is somebody you do stuff all the time with, and this is going to get you maybe into certain clubs, certain rewards programs. You might be part of other things that they do. That might be a good thing, right? For me, that might be REI, right? Because my family loves all that stuff, right? But there might be somewhere else that doesn't apply to you. So limiting the collection, unless you explicitly authorize it, of saying, you like, this is if you want to, not because you have to just in order to buy one of our products, as an example. They have to maintain reasonable administrative, technical, and physical data security policies. Now, this is really important. Everyone here has heard about the cyber breaches that have been going on pretty much nonstop throughout the business community as well as governments. That is unfortunately not going to stop or slow down anytime in the near future. So we need to make sure if somebody has one of our data, right, that they are doing their best in putting the right parameters in place to protect and secure that data. The controller cannot discriminate against anybody by exercising consumer rights. They do not process sensitive data without, again, obtaining your personal consent. And then if it's a child, again, specifically, a parental consent. States that a provision in a contract will waive the limit if consumer rights is void and unenforceable. It also talks about clear, accessible privacy notices that will be published and laid out on everybody's sites. You've seen this again today, too. You go to a website, and it has all these little references, usually at the bottom of the screen, or when you are going through the process of entering your information in, that if you live in this state, you live in this state, you live in this state, that these certain things apply. To continue on, and I don't want to read every single word in the bill, but the controller shall conduct a document and data protection assessment for each of the following processing activities. So targeted advertising, again, if we know something about Chairman Setzler because he's bought before, right? They're trying to target advertise you with the things you have bought and the sites you have saw before, right? So this is making sure data protection policies are in place from that and give you the chance to opt out. Processing personal information for the reason of profiling. So profiling is something you may have thought in the criminal justice world. We might have a detective who's a criminal profiler, right? They're trying to figure out what this person might be if they are committing heinous acts. Well, in the technology world, profiling has been being used really throughout the last dozen years now, and it's profiling consumers. It's from what you might have put on your Visa and American Express card because you're going on vacation, to if you have an open source email account, to where you're going on social media, to places you're buying out. And they are profiling you, right, in order to then target, market, and get to you based on what they think the habits are. We want to make sure none of that is unfair and deceptive. There is no injury to be done, and again, the ability to opt out of those things to protect you and your personal information. The state's Attorney General, Attorney General Carr, or future Attorney Generals may request that a controller disclose a data protection assessment to an investigation So if we think there's a problem there, it gives the Attorney General the ability to go in there and look and review and see what has happened. It also says a state controller who's in possession of what's called de-identified data can take measures to ensure the data cannot be associated with a person. What is de-identified data? Well, here's a great example. Let's say you are part of a prescription drug trial, right, where you're working with them. They will take off your name, your address, your information, but they may say, you know, in this group of people, the average age was 44 years old, and it was, 62%, women, 38% male, et cetera. But it's an aggregate of a study, but it de-identified all what's called your personally identifiable information. And again, talks through the different pieces and parts of that. Continuing on, the state in this article shall restrict a controller in their process to ability. So what we can't do is we can't tell a controller to do anything outside of complying with laws, with law enforcement, protected consumers. As an example, what we put in this bill would not supersede somebody coming in with a warrant from law enforcement if there was a problem. They would still have to comply with all the normal rules and laws as you can imagine they are today in order to protect the greater public. It states the obligations imposed by controllers and processors under this article shall not restrict the processor's ability to collect and use data to conduct internal research on their products, right? Let's say you filled that information, you rated their products, you gave them 4 stars, 5 stars, 1 star. Look at a product recall, right? So you went out and you bought that car, you bought that stove or washing machine, and there's a recall. They need to contact you because they might be subject to a fire or an airbag, something of that nature. Identify, again, any repair, any technical errors before internal operations that would be assigned with that, such as a warranty, as an example. You can see this is a pretty meaty subject of how it works, because while you want to be able to opt out of personal information, you still want to have a connection to make sure that you are protected. The question is, how far does that data go? Very different, as an example, if Chairman Payne, as an example, went out and bought a new stovetop. Well, we would want him and that company to stay in contact if they needed to reach out to him. Whirlpool said, hey, there's a problem with that stovetop, and we need to get a part out to you right away and fix it to make sure your kitchen doesn't have a fire, versus them taking his information and having 20 people be spamming him about redoing his kitchen. So, continuing on, again, this is a pretty meaty bill, and I don't want to go too fast, but at the same point, I don't want to read every line. A couple of the highlights I want to put out with you. In no way does this infringe upon anybody's First Amendment rights. I'm sure we can all agree upon that. States a controller shall not process personal information for anything else but the purposes listed within here. States that the controller processes personal information pursuant to the exemption of our code, which means they have to continue to follow this throughout the code and not find a loophole. That's a basic terminology here. Also talks again about the Attorney General giving them reasonable cause that if they believe a person, a controller, or a process has engaged in any violation, that they can issue and begin a civil investigation upon them. That has happened in a couple other states, just to let you know, where there were some bad actors. I think what really came out of that, though, was the law really kept the honest people honest. The bad actors, once they felt that there was consequence to their action, started to back off, and I think that they've seen pretty significant improvement in the states that have passed this up to this point. And continuing on, again, it says the Attorney General will again have the exclusive authority to enforce these articles. The states a court may impose a civil penalty of up to $7,500 for each violation. Again, you can imagine that could be a pretty hefty fine for each violation. Court may award treble damages if the court finds section was willfully violated. And in this case, and I know this is one area that we'll probably want to talk about a little bit more, Mr. Chairman, you brought to my attention as well as others about the concern for the private right of action. And just really rounding things up, one of the things that we have been continually talking about when it comes to anything protection and cybersecurity is what's called NIST standards. That's the National Institute of Science and Technology, or Security and Technology. And what that is designed to do is a framework that's internationally used to make sure that we're protecting things in a consistent and compliant manner. And last but not least, it's the typical making sure this doesn't conflict with any other laws that are currently on the books, and it states that no municipality, county, or consolidated government shall require a control or process to disclose personal data of consumers unless it's pursuant to a subpoena at a court. So what that basically means is a city or county can't go to a controller and say, hey, give me all the information about your customers, right? Because that's just as bad as them sharing it with other people without your consent, unless it's a public safety issue, right? There's some type of action going on, at which point they would go to a court and get a subpoena, as they should in anything else with personal data. Again, I know this is a very hefty bill. There's a lot of information here. I really want to thank the members of the Chamber of Commerce, both Metro and Atlanta. I want to thank all of the key stakeholders that have been a part of this process and getting it here before your committee, Mr. Chairman, and I will stop and yield for feedback.
Thank you. Appreciate your presentation, detailed walk through this. There's a lot in here. What are the questions from members of the committee before we take any testimony? Questions? No questions? Okay. Couple things, just areas of interest that we may come back to. I want to hear some testimony on. As I was reading through this, I'll just touch through these briefly with you. And again, I love the robust definition section. You know, there's a lot in definitions we always want to scrutinize, want to make sure we're solid on. I would say just, and again, I'm going to touch it here and come back to it. We won't delve into it too much. On lines 145 through 149, the definition of sensitive data. One thing I appreciate about the gentleman's effort is that we're not treating all data as being equal. Some data is a whole lot more sensitive than others. There may be some ways we can, and I don't have any issues with a list here. There may be a couple things outside of this. If you tap into Section 161281, nudity, images of sexual conduct. If there's things like that are being maintained, that be treated as sensitive as well. And there's an easy way to look at that. But I think this definition is a very good definition. Certainly some very sensitive things. There may be some expansion to that we could look at. So if people have photos and that kind of thing of themselves for whatever reason, that be treated in that way. I know you've got photos of people under the age of 12 is already in this. So that was a question that was raised as we stepped through this. Into the author, lines 186 through 191. Just to my perusing the bill, I love this, that the consumer can invoke these rights even if they had at some point given consent, sort of draw that back in. The question is, how do you do that? I've tried to get in touch years ago. Some political opponents opened up a Twitter account that was a spoof Setzler Twitter account, and I couldn't figure out how to contact Twitter. Twitter, as lobbyist may be here, I'm not still complaining about that, but it was interesting. How do you reach out to some of these entities and contact them? I think, as a matter of policy, if there's a way you were interacting with the entity and gave consent the first time, is there a way that could mirror that on the way out?
And if I could just interject,
Sure.
I've had this similar thing happen to me in the past. You will see that almost every website you go to has an area that will either come down ahead of time or it is going to flash up or at the bottom of the screen about the privacy policies, right? And if you have a problem with this privacy policy now where they have to act because of the laws the other states have put into place, that's pretty much a guarantee on anyone that's going to have your information at this point. Having Georgia there would make sure we capture anybody else who's here that might not be under that. But you're right, Mr. Chairman, they absolutely need to give you access, and then if you look, they have that 45 days to provide a cure for that.
And the big players, probably who have people in this room, are well down this path doing that now. I think the question is, are there other players who are more mid-market people that are still collecting information. You know, just maybe some clarity on how somebody would interact with them. Couple things. I know there's some concerns about opting out of controllers' processing information, like the purposes they can use it for. You might opt in to say you can use it for this and this, but not for that and that. You know, exploring, you know, or getting what someone's information might be used for. That's just a couple questions I'll have for you. And I just raised this as we hear testimony from others. They may be talking these same kinds of issues. We'll take all the time. I'm just raising some things as I read through this. Also, you know, the Attorney General being the only actor that can, or the only entity that can act on this. You know, are there other? Does a citizen, certainly a class of people working in a national effort, where other attorneys general are engaged, that makes a lot of sense, perhaps. But if you've got individuals, smaller groups of people, are they going to be able to get the Attorney General to act on these things? Does there need to be some other entity that can advocate for them? It's just a question I would ask. And then three other things just that I wanted to put on your radar screen. On line 535, there's a list of entities. This is a really long list of entities to whom this whole article, this whole bill does not apply. State agencies, financial institutions, insurance companies, nonprofits, institutions of higher education, entities that are regulated by HIPAA for medical information. I understand a lot of this because there's already a framework there. You know, nonprofit organization, you know, I certainly don't want to be hammering, you know, the Junior League of Marietta for maintaining information on their members or a church. I do think maybe we would think about if there's a nonprofit that is operating, even though they're a nonprofit as such, operating in a for-profit capacity for beneficial consideration, generating revenue as a business model, even though they're a nonprofit status, they would have complete safe harbor from any of this.
That's a great point, Mr. Chairman. I think that would be a necessary add.
And then just stepping through this, talked about the AG piece. NIST, I like that reference. There's been some criticism that the NIST standard is not a very high bar, but at least it's a solid place to stand. I was a little concerned on 10-1, line 645 through 662 that it's not just NIST, it may be other documented policies or frameworks. You know, if NIST is a low bar, and there may be some people that think it's too low, at least it's a solid place. That's why I like the fact you're referencing it. Maybe opening it up to any other policies may be too broad. You know, I just wanted to raise that. But I think the local preemption's appropriate. I like that. I like where you're going. These are just some things that I was reading the bill and thought about.
No, thank you. I appreciate that. And you're right. I mean, NIST is the foundational layer. You know, a lot of people will take that up, and then within NIST, there are different governance frameworks that are subsections of that get more detailed, as well as people tend to go to like an ISO 27001. There are other things that continue to move up the ladder, but we want to make sure there's a base there. So thank you.
Super. Well, appreciate you, Mr. Chairman. If you could stand by, I'm going to recognize, we got one person signed up to speak. Ben, I still can't read your last name.
It's Line.
Line, thank you. Ben Line from the ACLU of Georgia. Ben.
Mr. Chairman, would you mind if I just stayed here
Sure,
with Ben?
yes,
Okay.
betcha.
Great.
Love to share the table with Chairman Albers. Good afternoon, members of the Senate Science and Technology Committee. For years, consumer rights, racial justice, and civil rights advocates, including the ACLU of Georgia, have called for meaningful privacy regulations that empower people to live their lives free from intrusive corporate surveillance and to discrimination that could be empowered by technology. We are so excited that Senator Albers has brought forward language on this bill today. I think Senator Albers was the first person I spoke to when I started this job, and it was specifically on this issue when we were talking about language. So the fact that this is something that's being taken seriously, we just want to thank Chairman Albers as well as this committee for considering the bill. That said, the language as it exists in SB 473, being based on the Tennessee law, in our view, does not meet the requirements to protect people's privacy and would legitimize a status quo that protects big tech companies' profits and not the people's privacy. The ACLU of Georgia urges this committee consider putting the privacy of Georgians first when considering language that would be more effective. I'll get to some of those in a little bit. I don't know if any of you have tried to rent a house, rent an apartment, or buy a car, or do other types of things like that where there's scams that have been taking place in the commercial setting. But you're often going to be required to provide your iris pattern, your facial geometry, and your fingerprints. I know when I rented an apartment a year and a half ago, I had to provide all of those. And when I was buying a car, I had to provide just my facial geometry to the car dealership. Right now in Georgia, I have no control over how that data is used, how it's retained, and how it will be disseminated. Corporations have built a surveillance economy that seeks to collect as much information about about a person in order to turn a profit. Just as those examples I just gave, they can harvest data from what we do at work, what we do at home, what we buy, where we go, what doctors we see, and our contacts with the criminal legal system. At the federal level, these companies face almost no real restrictions on the amount of data, personal information they can amass, or the ways they can use or exploit this data. And in the absence of meaningful state protections, companies have compiled massive dossiers on each one of us containing staggering amounts of information. This information can identify us from our interactions with the world, that's both online and off, within our homes and outside of them, creating the potential for private surveillance on a massive scale. And when we're talking about the issues of biometrics, especially when it comes to facial geometry, our iris patterns, and these kinds of information, we don't know the scope of how this information can be used in the future. Technology is changing, especially with the interplay with artificial intelligence. So we see right now, and it's why we do thank Chairman Albert for bringing this bill, that we're kind of at a threshold moment in terms of our ability to control this data now. Some information that can be sold to data brokers or used to power surveillance-based advertising. We have seen in other states discriminatory impacts when companies exclude people from their businesses or advertisements for products they would buy based on their race, gender, or nationality. In order to stop these harms, consumer privacy legislation must, at a minimum, contain strong restrictions on the amount of personal information that can be collected and the ways it can be used, requiring opt-in consent before companies can collect this data. And that's one of the biggest things from this bill, where when it talks about the data center, the majority of which would be opt-out, and so giving them that opportunity instead of requiring that affirmative consent. Providing users with the tools to access and control their personal information. There are some of those protections in here, but when it comes to de-aggravated or depersonalized information, that control no longer exists. And creating strong civil rights protections. The only civil rights protections I saw in this bill, with the exception of some base language about race and gender, which is a good starting point, but it's not concrete civil rights protections. The only reference to the Constitution was the right of the companies and their First Amendment rights, which should be protected, obviously, but we think that there should be stronger controls. As well as enabling people to sue privacy-violating companies for attaining their personal information for their monetary relief and abusing these practices. We don't think SB 473 goes far on any of these issues. And that's why we're asking this committee to put Georgians' privacy first. I've sent a memorandum to every member of this committee with our blue ribbon model language, which we think is the representation of all the bills that I know that Senator Albers has looked at. And when looking at it from a privacy standpoint and putting consumers' privacy rights first, it takes out all the strongest elements and puts that in one bill. Again, I'll go back to say that I think we're in a bellwether moment about what we can do right now. So when we're thinking of language, I think that putting it on the onus on companies to build on a platform that protects privacy is what the bill that should come out of this committee would be. And we've suggested 5 states where language has either been passed or is being promoted that does put privacy first. None of these bills goes as far as we want them to, but they would serve as, we think, better alternatives with the language. The Texas bill in particular doesn't go anywhere near as far as we would want it to, but has been in effect for 12 years now with no changes from what I've provided in the language that you have in front of you. And I think this is a compromise we can all live with. If businesses can do business in Texas, I believe that they can live with it here, and it's putting the data rights of consumers first. It doesn't contain a private cause of action, which will always be a sticking wicket, but at least if we get these protections, that can be something that we can look to down the road if it's necessary, just as tech companies can look for exemptions as they're necessary. But we think that the bill that comes out of this committee should, as a baseline, put these protections first. With that, Mr. Shellman, I'll yield for any questions, and I'm happy to explain any items in my memo as well.
Appreciate your presentation. I've got a few. Are there any questions from members of the committee? No questions? Chair recognizes the Vice Chair.
Could you go back over the list of states you said that had?
That's right. So in your materials that I provided, and I'm happy to resend the memo. Actually, I should have it in front of me.
And I would tell you, just not to shoot too low.
Yeah.
You send email to members during a legislative day.
I understand 100%.
They're not printing these out and reading these things.
Of course. And so I would love to, as this body's considering further details, I'd be happy to print out that bill language and get it to people. But the just a second. The language, if I remember correctly, it was Illinois and Texas are the ones who have passed the laws, and I think it's Washington, Massachusetts, and one other state that provided language for that has. And the critical things in those bills are the opt-in consent, which is basically if they want to be using your information, just like when I tried to rent an apartment, they have to say, we're collecting this data and what we're using it for. Other things that are required is the ability, requiring businesses to destroy that data after a certain period of time. I think the Texas bill, as well as our model bill, uses a year after the last contact with that person or for the purposes of the collection. And they also have it where there's data minimization. The data minimization in this bill is for the purposes that are disclosed, and that could be buried in a privacy statements, and not necessarily the purposes why that consumer engaged that company. And so we think that that would be a necessary thing, and that's something that those bills that we provided language for actually include.
Okay, thank you.
Thank you. I had a few questions, and I think I lost some of them in the discussion. You talked about the opt-out versus the opt-in, and you talked about the multiple states, sort of this, and that's something that Chairman Albers alluded to. That
100%.
We're already seeing this movement across the marketplace. It's easier, I guess, for businesses that operate nationally and internationally to have one standard, maybe at least across North America. Maybe they have a different one in Europe under their GDPR rules, but maybe one for here that's more common. So it's some states adopting a standard starts to make it happen other places. What specific movement have we seen as a result of specific policies that you alluded to? Are we getting opt-in opportunities in Georgia because some states have required opt-in?
I would not. I have not seen any data to suggest that that's what businesses are doing. It was more of the understanding I had when I was going to, go back to the apartment thing, there was no opt-in consent. It was, if you want to apply for an apartment here, this is what's going to be provided. When I would push back against that, because I don't want my iris patterns or facial geometry to be recorded by, that was told, you can find somewhere else to live. So I don't think that that is something that's being reflected by these smaller people who are collecting data right now. And I think that's another point that's important to mention here, that we actually look at who's covered by this article. We're talking about the small property management company that I did that through when I was running an apartment wouldn't be covered on this bill because they don't collect data of over 25,000 people with a certain number of business context for selling data. So I think that that's another important thing about this bill is the scope of who it actually covers is somewhat limited. But I will say, in terms of movement, that Georgians have actually had increased protections regarding their consumer data because stronger bills were passed in other states. That's absolutely true. There was a very large lawsuit that occurred in Illinois based on a Consumer Protection Act that actually protected Georgians from having their data collected for 5 years by some known bad actors, and that's something that so Georgians were actually able to benefit from the actions of their states. And the reason that we would like to see stronger protections here is because I don't want Georgians to have to rely on the protections of other states. I would love to see language in this state that protects Georgia's rights first.
As you mentioned biometrics, I had a credit card breach that happened. Someone got my credit card number and they were running things up. My wife was texting me, "Did you buy something here?" I was like, "No, I didn't buy anything there." So we had to clear our credit card. Same thing can happen to passwords and such. Question about the biometrics. I can blank my credit card in a couple days. They can FedEx me a new one, and I can be up and running again, and I can travel and the things you need to do with a credit card because it's replaceable, as is a password. My concern around biometrics is that I can't wipe clean my iris scan or my fingerprint. It's indelibly mine, and if someone owns that, they own my biometric forever.
And Chairman Stutzler, what I would like you to consider as well is, because that's very well stated and it's a huge issue, but what also I would offer to consider is we don't understand what information could be gleaned from information. Is there some genetic material that makes our iris pattern work a certain way, or facial geometry work a specific way that can be used against or discriminated against consumers that we just don't know the scope of?
That could be. And so I'm not dismissing that.
Sure.
Maybe I'm dismissive a little bit. What I'm, I guess, more concerned about is on that front.
Right.
I can never undo I can't change my finger. I can't go in and have my nose can be improved more easily than my fingerprints can be, right?
Yeah.
So when we talk about biometrics, we talk about, essentially saying a violation shall not serve as a basis of any right of action, class action or individually. So if a small entity, like your apartment complex, lost your biometric, you have no action. The law is kind of a Wild West right now relative to that. You may or may not have an action.
Right.
Under this, if a big actor lost them at scale, there's nothing you can do because there's no private right of action and there's no ability to do a class action lawsuit if they lost biometrics at scale, as I see under this. Is that your read of this? I know I talked to Chairman Albers about the civil side of this, creating that balance.
And so one thing I would especially caution, and that language you're referring to is lines on 641 and 642 of the bill,
yes, sir.
Where it limits the cause of action or a basis for under this article or any other law. And so with that, especially with that caveat of any other law and other consumer protection that might be available at the state level in terms of fair business practices and that I might have a claim for, or in tort I might have a claim for, that this could preempt that with regard to large companies.
My biggest concern, as I shared with the chairman before the committee, was this 641, 642. This creates an absolute, almost indemnity. You're unsuable as an individual for the only one that could ever bring a suit against you is the Attorney General, no matter what happens civilly. That's something we're trying to. I know the chair was. We've talked about that piece and what that meant. So I just wanted to. Your remark about the biometrics catalyzed my thinking on that. So. Yes, sir, Mr. Chairman.
Mr. Chairman, if I could as well, I always appreciate Ben's insight and wisdom. I think we always want more, right? And if I've learned nothing in my service down here, and you and I have been here for a minute now, is sometimes you have to take incremental steps forward. Yeah. And in lieu of having nothing, I think we can make some necessary tweaks here, but in lieu of having nothing, we're advancing the ball forward. And I think if we can do that in a way that everybody gets a little what they want and other people are a little bit disappointed through that process, that's probably a pretty good bill, I've learned while we're down here. Yeah. And what I don't want to do is it be an us and them between our business community and others, right? We want to come up with something we can all say, you know what, this makes sense. We're moving the ball forward. Now, here's what I can promise you. in the years coming, this will change because technology is rapidly evolving in real time. So will we be back here in 2 years from now, probably in the same room doing this again because something has changed? The answer is absolutely. And a lot of that will be driven by artificial intelligence. But for now, I think the premise of the bill is very strong, maybe with some great wisdom and tweaks that you and Ben have brought forward. But I would urge us to think about something as 100% more than nothing.
Well, I don't know what Ben's got. I spoke to him for 5 minutes in the hallway today, so I don't know if he has any suggestions. I'll leave that to you. Anything else you'd like before you wrap?
Just, thank you, Mr. Chairman. The only thing that I would, it's another caution, is this safe harbor provision. I believe that, and that's on lines 646 through 662. I believe Tennessee was the first state to adopt this safe harbor language, and I do think that I have no concern about NIST. I think that they're a great company in providing practices for companies and how they engage technology. As a person who has a difficult time just turning on a computer, I defer to their wisdom a lot when I talk about data and privacy. I'm concerned that this bill, with that safe harbor provision, as good as NIST is a floor, is actually creating that NIST standard as a ceiling, and especially with this preempting other local action and the private cause of action, that's just another thing that I would flag for the wisdom of the committee. In terms of, I would just go back to my recommendation that I agree 100% with Senator Albers regarding that anything is better than nothing, and Georgia's rights should be protected. I would, again, just go back to the Texas bill. It's 2 pages long. And in terms of doing something, it does set a floor that's been, again, used in Texas for 12 years that puts consumer rights first. Instead of, again, as much as I know we want to maintain Georgia as the #1 place to do business, in this space, I think that those consumer protections should be what the highlight are. And that's all I have.
Okay. Appreciate your time.
Thank you very much.
Any discussion or questions from members of the committee about anything we've discussed so far? No. Okay. Okay. To Chairman Albers, I'm willing to jump into some weeds on some things. I can share some language I've pulled together to address some of these issues. Would you rather address some of these here? Would you rather go offline and talk through some of these? I'm gonna leave it up to get your thoughts. I know we're
Certainly, yeah. In 12 minutes, I've got to hear a great bill from you and my committee. So
Right.
If timing allows, happy to go through it now. If it makes more sense to do those offline and bring back a committee sub in the next couple of days, I'd be happy.
Well, I think that where I am on these, I think these are all really good, but just because I think that, I know you've tried to craft a consensus from a lot of people. There's a lot of folks, I wish there were more people from industry who are back here talking to this. I know there's a lot of there's a lot of watching. We can wave to you guys. But what I do want to do is make sure we've got, even though this committee could, or maybe the 4 of us could be satisfied that we've got a good framework, I want to make sure that we're taking the deliberative steps to do it. My goal would be, if we don't act on this today, is have a committee meeting on Tuesday, first day back. My policy when I was eons and eons and eons ago when I was a House member was that we would never fail to act on a bill because of my inability to schedule a committee meeting. So we may be back in here soon. So my goal would be either we act on it today, and I've got some amendments, but again, that's not necessarily going to get, we could talk about them internally, or we could work this afternoon offline and schedule something Tuesday where we've got a chance to staff this, whether it's a sub or otherwise, and we kind of know where we're going.
I think that probably makes the most sense, Mr. Chairman. I think we want to be really transparent with all the key players here.
Yeah.
And I think if we can get the key players on all sides, as well as our legislative council all together, we can come up with, the committee sub, and we can just outline the differences between the original and hopefully Tuesday have a great bill moving forward.
I mean, a 27-page bill is not unprecedented coming through, on a subject like this, but the scale of this there's a lot of scale. And I don't want to put upon our committee members, I don't want to put upon our members on the floor that any sense that this was rushed. Although I brought things, we're prepared to act on these today, but if you think Tuesday makes sense, we'll get that scheduled now.
meeting scheduled on Tuesday?
My schedule man's right here. We'll get it done.
Okay, perfect.
We'll work with you. We'll schedule around your availability. We'll make that happen.
Thank you very much.
And
I appreciate
I
it.
want to talk specifically with you on some details. Chair recognizes the vice chair.
I just wanted to say thank you for this bill because I agree with the chairman that we need to make sure we get it right, but I think it's far needed. And thank you for your work on this.
Thank you.
So, Chairman Albers, you have the last word. Anything?
I want to thank you, Mr. Chairman, for the time you've put into this, to your committee members, to our friends that are behind me, as well as Legislative Council. When we come up with the final one, we'll ask them to come forward as well from the different chambers to express the work that they put in it as well, so everybody can hear from them at the next meeting to make sure we have what I like to call a grand compromise, which would be perfect. Thank you for
Well,
your time.
this was not a hearing only today, but I don't like to have hearings where I say hearing only because that sort of tunes down people's thinking. But I do think the discussion we've had today has been good. I would expect a vote on Tuesday. So we will schedule that. With that, we stand adjourned.
Thank you.